I thank the ranking member, and the chair now turns to the chairman of the Education Committee, Mr. Rokita.
I thank the chair. I also thank the ranking members. Excellent testimony from everyone. I've really learned a lot, and will continue to learn as this issue goes forward. Ms. Popp, I'd like to start with you. I'm always encouraged as a former statewide elected official when we have solutions that come from the states. That's how this was set up, and I'm particularly pleased with your testimony. To make sure I understood it right, are you saying that the 1372 or whatever number it was prescribes contractual terms that have to be used when districts contract, or by virtue of the statute alone it's saying what's prohibited and what's allowed under districts' usual procedures?
Thank you, Chairman. Senate Bill 13...
Ms. Popp, I'm going to ask if you speak into the microphone and make sure that you push the button.
The red button's on.
Okay, great. Thanks.
Thank you. Senate Bill 1372 was very clearly outlined what data and how data can be collected. It also addresses the fact that there is a monetary penalty for any breaches. It does not get into some of the very specifics on some of the policies that the Department of Education, however, has adopted. One of the things being the contractual component. It does in the Senate bill address some of the information on contracts with third-party vendors, however, such as testing agencies and student information systems. It actually calls out those two particular vendors directly in the Senate bill.
Mm-hmm. Thank you very much. And Mr. McCarthy, what do you think of Idaho's approach? What would your members think?
Thank you for your question, Mr. Chairman. We like the approach.
Good.
I think it sets up the proper sort of framework for the inclusion of the appropriate issues within school contracts. As many of you have heard in previous testimony, transparency is a key element. We need to tell parents what information is being collected by the school and the school vendors, what's done with it, who it's transferred to, who it's shared with, what the data security requirements are, what the data breach notification requirements are. That information should all be provided to parents, and model policies at the state level that make sure that those issues are covered in contracts are something that the industry would support. They're part of the SIIA best practices that we put out in February of this year. So we would encourage that level of involvement by state and local and school districts.
Well, thank you. And Mr. Reidenberg, what do you think of Idaho's approach?
I think it's very encouraging. Sorry, I think it's very encouraging, Mr. Chairman. I also think it's extremely positive that the Idaho Department of Education is spelling out what the contracting practices need to be for the districts. I do think, though, that kind of approach needs to be seen on a nationwide basis, and that it's not just the students of Idaho that deserve the kinds of protections that Idaho is enacting. The federal government is funding in the last couple of years it's probably between $500 million and $1 billion to the states to encourage and be developing these kinds of information systems. And I think we need to see approaches like that more systematically deployed across the country.
Do you think Mr. Murray has a good idea when he says Title II funds ought to be used in this area? You know what Title II fund?
And I'm sorry,
teacher prep and those kinds of things. In fact, the Student Success Act that our whole committee passed and that sits on Mr. Reed's desk right now, block grants a lot of Title II funds to the state so that they could use these funds in the best way they see fit. Wouldn't you say states should be able to use federal money to help protect or enforce issues in this area?
Well, I think that if the federal government is going to be financing these kinds of programs at the state level that require the generation and collection of lots of student information, then there ought to be a commensurate requirement that the states address privacy as part of their infrastructure development. On the teacher, you said I'm not very familiar with Title II. To the extent that it's involving, say, teacher training programs, that's a key part.
Mr. Renberg, my time's run out. Two short remaining questions, yes or no. Do you know of any legal malpractice cases occurring in the U.S. that involve attorneys for school districts or schools in this area for their lack of preparing a contract correctly or anything like that?
I'm not aware of any.
Are you aware of any school district in this country that doesn't have legal counsel?
Yes.
What percentage of the total would you think that is?
That I couldn't tell you. I mean, we saw school districts, the smaller school districts seem to be winging it when they come to these sorts of contracts.
Mr. Chairman, I thank you for the time.